We are back on Morning Line. Our guest with us this morning, Barbara McGinnis, Elder Care Law. If you have questions about the law with regard to things like estate planning and wills and power of attorney, give us a call. Your chance for some questions answered by the attorney. And again, free legal advice is always a cool thing. Barbara McGinnis, wanted to follow up with you. You know, I have several friends, who have autistic children, some high functioning, and they're doing well. And I think they can have full lives, but they're such that even as they now are reaching high school and college age, it's clear that they will always need some degree of care, and they continue to live with their parents. And you wonder, the parents looking at them in their 20s, well, another 20 years from now, the parents may pass away. And this 20-year-old now who's still with him is going to be 40 and cannot live on his or her own. And you just wonder, as they think ahead to the future, about estate planning for their child. And I guess it varies on what kind of resources they have. But what do you say? I'm sure you've seen cases like this. How do you, when they come to you and say, how do we set things up for 20 years from now when we're not going to be around, and clearly our son, while doing well, is not capable of living on his own and never will be?
Right. So the legal planning is probably some of the easier part of the planning, right? Because we can create the documents that will help support them meet the goals of caring for that child. Perhaps it is a testamentary special needs trust that would hold the assets that they want to be used to care for that person, to supplement their needs throughout the rest of their life. Identifying who would serve as trustee after the parents have both passed away. Who would be that trusted advisor? Is it going to be another child of the couple, that a sibling of the disabled person that would so serve, or an aunt, an uncle, somebody, or is it going to be a trust company? Sometimes identifying that trustee is a challenge for parents. Who do they trust to take care of their child? And especially when they're not there to supervise. But maybe a plan would be, let's create a living third-party supplemental needs trust for this disabled child. So the parents could serve as trustee during the child's lifetime, but we could have a successor trustee already appointed that, let's say, we're training our trustee to how do we take care of the resources to provide for our special need loved one, and the parents are there to help guide them and teach them how to do that. The harder part of the planning is what kind of resources in the community are available for these people. What group homes, educational programs, this general support network is perhaps a little lacking in Tennessee. And there are few people that really understand how to navigate those resources. One person that I've encountered that is very, very knowledgeable is a lady named Jen Stoops at AROSA. And she is a true expert on the resources. So putting a plan together for your special needs child is somewhat the legal aspect. That's going to help protect the resources to provide care for your loved one, but also then knowing what the community resources are available and creating a plan of support. Because it's very likely these people will live long and sometimes very full lives. They just need support.
Right. That's it. And it's got to be, just so important, peace of mind for the parents knowing that day is going to come. And that's it. And the resources are there. There's a way to do it. You set it up, and that's how you move forward to make sure that they're cared for. Another thing you wanted to talk about today was the concept of undue influence. All right. I like to think I have some undue influence over you, Barbara.
Well, you have influence over me, Nick, but I don't know that it is undue.
Oh, okay, good.
And
I
that's
think you're
really,
right.
yeah.
I will
That's
ask
really
you questions, I suppose. But, okay, what is undue influence and how it plays in legally when you're dealing with different situations?
You know, we have lots of people in our lives that can influence us, that gives us suggestions, and we seek out their counsel. It might be professional people, but it might just be friends and family members. And that's completely normal and allowable because that's part of the way we function in society. Undue influence is where one person that has a certain degree of control over another person uses that and leverages that authority to their gain.
Okay.
For example, a caregiver, maybe it's a family caregiver, maybe it's just a paid caregiver, persuades a sick, frail, vulnerable elder that, but for them providing care to the elder, they'd be in a nursing home. And so they need to be really good to that caregiver or they're going to have to go to a nursing home. And nobody cares about them the way they do. And the elder should probably go ahead and give them some assets now, or at least include them in their will because they've just taken such good care of them. Do you see that position of being the caregiver is a type of authority? And they're leveraging their relationship to their financial gain. And that is undue influence, an example of undue influence. And it's important because when that elder passes away, the natural heirs could challenge that the will was rewritten under undue influence, and it just is ripe for a will contest.
And that's how you wonder how you prove it, because I can see both sides of this. I mean, you made a really good way of describing that. I understand undue influence now and where you go. Now, there may be some cases where there are children, for whatever reason, who have abandoned their parent. You know, they never got along, and they're just out of it, okay? And a neighbor who lives next door to this parent, for whatever reason, over several years, is really kind of a caretaker, has done everything for him. And the parent, on his or her own, decides, when I die, to heck with my kids, I'm leaving my house and stuff to my neighbor, and writes it that way. And the neighbor may never have ever brought that up. The neighbor may have just been a good person who helped, seeing that the children were never around, and helped this parent. And this parent, on their own, realized, you know what, my good-for-nothing kids, see ya. This neighbor was here for me the last 10 years of my life, and I'm leaving this. Now, that's not to say when these good-for-nothing kids come expecting to get the will and see this, they're going to flip out, and they're going to want to challenge it. How does it play out in court? How can you prove it one way or the other?
So in your scenario, you know, pretty different than the scenario I was describing. Adults can leave their assets to whomever they want to leave them to. The difference is the neighbor did not do anything to persuade or coerce the elder into changing their will. They didn't take them to the attorney's office. They didn't call the attorney's office for them. You know, there's no evidence of them actually persuading them in an undue fashion. You know, it's perfectly common. Actually, we have clients that may have multiple children, 2, 3, 4 children, and there's one that seems to be the one that's really stepped up. They're the ones that is always around to do for the parent. And the parent may say, I want more of my estate to go to this person. And again, the parent says it on their own free will without the child sitting there going, now, Mama, didn't you want to tell the attorney something? Didn't you want to tell them that, you know? So it's different. It presents differently. And it wouldn't be uncommon for
Would it be wrong, Barbara, if let's just say there was the one kid that busted the butt and was there all the time caring while the other two never paid attention at all? And would it be wrong for that kid to say, come will time, Mom, you know, I've sacrificed my career and everything to be here with you. So when you die, I wouldn't mind getting the lion's share of it. I mean, I wouldn't have a problem with that. I mean, the others may not like that, but I mean, the person who stayed, just because you encourage your parent to leave more to you, if you're the one that was the one sacrificing to be there with them for the last several years, what's wrong with that?
Well, it could be used against you.
Okay, I'm saying it could be, but if I'm a jury and I'm a
Yeah.
judge and I'm like, well, you were there for 10 years, you gave up your career in TV broadcasting to stay home with your dad and care for him for the last 10 years, while your two siblings were off doing and didn't have anything to do with it, and they're saying that you undue influence on your dad. I don't care what influence you had. You cared for him and took good care for him for 10 years. You should get the lion's share. End of story.
And a lot of times how we'll help, and that may very well be true, and it may be exactly what the parent, the elder wants, and we will encourage them to talk to the attorney separate and apart from their, like, not have the child in the room.
Sure,
So we're just talking to mom or dad, and we want to make sure that you're not being pressured into making this change. This is really what you want. Does the person still have capacity to make that decision? Do they understand that they're not dividing their estate equally? Perhaps their previous will said to all of my children in equal shares, and now their new will is going to be heavily weighted to this caregiver child. Maybe it makes sense to go ahead and state in the document that the why, but I think it's the attorney's determination to make sure that the person still has capacity. It is their desire, and they've not been unduly pressured by the caregiver child to make the change.
And I understand why that's very important. We'll go to the break, but on that note, I want to say this too. I know personally of cases where there was one sibling that did stay in the house and care for the parent for years, and the parent finally died. The other siblings were well aware of this and appreciated this and had absolutely no problem at all with that home going to that sibling, because that sibling was there and the other children understood and they felt that sibling deserved it. And, you know, that to me is a good family. The ones who are fighting over money, I got no use for them. We're going to take a break. We'll be back with more calls right after this.